Hello, welcome. I'm sorry for the delay. Food will arrive soon. But in the meantime, we have a treat for you, which is that Greg Day, who's Associate Professor of Legal Studies at both the School of Business and the School of Law at University of Georgia, has kindly agreed to give us a lecture today. Welcome, Greg. We're looking forward to your talk.
Awesome. Well, thank you so much. So, as you said, I'm Greg Day from the University of Georgia, and I guess I've heard all the other events. I'm really honored that people would come to my talk. So I really do appreciate the invitation and being here. So my goal here is I want to talk initially about how sort of like lawyers and the law and legal scholars, how we talk about time, or how sometimes we don't talk about time, and specifically in using antitrust law as a vehicle for that, but also in addition to show the greater implications just kind of throughout the law about how sometimes how the importance of time, but also sometimes how we make implicit or express assumptions about it. So just to give you a quick like sort of primer background on antitrust, because I find it really, really interesting how sort of like the Sherman Act came about. So it was enacted in 1890. And with the rise of trusts and monopolies, but the states had already been enforcing their own type of common law of competition adopted from England at the founding, but they were having a lot of trouble because in the pre-Wickard world, they could really only scrutinize sort of like activities happening within their borders, so multi-state trusts and monopolies were kind of running free. And so they enacted the Sherman Act, and this is sort of a key part of the story. So Congress didn't know what to do. Like they didn't know what should be illegal. They had very little clue. They were kind of confused. So what they did was they enacted a statute that was very broadly worded. You know, so Section 1 is there's two operative sections. One is Section 1 that makes every contract combination in the form of trust, you know, in restrained trade or commerce illegal. Another one prohibits every person who shall monopolize or attempt to monopolize any part of trade or commerce. And even the Supreme Court has said, like, that's impossible. Like this statute is so broadly worded, saying that every restraint of trade or monopolizing any part of commerce is illegal, that like that essentially any contract would be illegal if we were just to broadly enforce it. And the reason why Congress gave such a blank slate is because they're like, well, courts can figure it out. You know, we have things like the common law of competition, so we're just going to textually just draft like the broadest statute we can and just let courts figure it out over the years. And so with that broad slate, it was a little difficult, you know. And some of the problems was antitrust was kind of populist, where it was just like where if you were big, you were bad. Other issues were and courts didn't even kind of know what was anti-competitive versus just competition. It was common a lot of times for courts to say, well, we should protect small competitors even if they charge higher prices. So they condemned like a lot of times bigger corporations that were more superior and efficient and to preserve smaller companies. And with this, it created sort of this backlash that led into the 1970s. And this was the Chicago School, which everyone's probably heard of, came about. And they said, like, we need to narrow antitrust scope. We need to think more rigorously about what antitrust should look at. And by doing so, they first said, like, only economic problems, looking at the history of antitrust, we think it's only an economic doctrine. No longer should social or political concerns drive antitrust. And then also, beyond that, they said, like, it should only actually be things that harm consumers. So instead of just saying big is bad, we should say, like, how are consumers harmed, or how is the market actually harmed? And one of the founders of this movement said, he had a book called The Antitrust Paradox. And one of the reasons why he said is currently antitrust is harming competition. Because right now, if you just compete really hard and just offer, you know, low prices and drive companies out of business by being superior, you could suffer an antitrust violation. And this is actually harming competition. And so the Supreme Court essentially adopted this approach in the 1970s. This, as you see, this isn't textual, this is just kind of theoretical. And this is now sort of what antitrust looks like. There's a couple key assumptions that kind of drive the paper that I'm talking about. And I think this is important to this is part of the reason for all this background. But a couple of the key assumptions is one is market self-correct. And the idea is like if there's one gas station in town, like in New Haven, that charges $10 for a gallon of gas, and that monopoly, that shouldn't be illegal. And the reason is because these high prices, it incentivizes other companies to show up, you know, other gas stations to open up, charge $9, then the monopolist will have to charge $8. You start this price competition because of the high prices, and next thing you know, everyone's just charging market prices. So part of the argument is that we don't really need antitrust when markets self-correct. The second theory is, well, you could use antitrust, but in fact, we think that a smaller scope of antitrust is better. There's a big paper in the 1980s by another Chicago guy, Frank Easterbrook, and he said that, one thing that we think is that like too much antitrust is a bigger problem than not enough antitrust, and again has to do self-correcting markets. The theory is that if you were to overly enforce antitrust, and we find there's some really innovative, thoughtful ways of competing, but we mistake it for anti-competitive behavior, that's problematic because when we condemn it, it's gone forever. Because every other company after that will be like, hey, that's anti-competitive, that's illegal, we can't do this. But if you under-enforce antitrust and say, yeah, we're gonna miss a few activities, that's actually probably better because markets will self-correct in the long run anyways. One way destroys good activities forever. The other one is uncomfortable for just a period of time. So we wanna like err with under-enforcement. And another theory that kind of drives up IP law is that like, sometimes monopolies aren't even that bad. Like they reward innovation, they reward business acumen, because you design a better mousetrap, you'll monopolize the market for a short period of time because then it will force other companies to catch up with you, and then the markets will eventually self-correct anyways. So based upon this, antitrust has really has become to err against enforcement. A lot of things used to be per se illegal, and courts have slowly said, we're now gonna make this, like you can justify this behavior under the rule of reason, it's no longer always illegal. During the Reagan era especially, antitrust enforcers said, we're just gonna really selectively pick cases. We're gonna dial back our enforcement activities a ton because we're just kind of scared about like error costs, about enforcing too much. So in one example is like there was a case where it used to be illegal to do something called resale price maintenance, where like a retailer and a supplier would agree to fix prices. That was always illegal, and the Supreme Court said that's now justifiable under the rule of reason, because if the RPM raises prices and has an anti-competitive effect, then the market will self-correct. Consumers will stop buying the product because it's too expensive, and other manufacturers will start selling the product at lower prices. But so far so good. That's the whole theory driving it. But maybe it's unsurprising that markets have gotten a lot more concentrated. You reduce antitrust by a lot, and then suddenly a lot more market concentration increases. But to the Chicago school, this isn't really a bad thing because probably those big firms are efficient and superior, and that's how they kind of got there. But we're making a really key assumption, and this is a lot where the paper sort of delves out of, is embedded in this is when we say that, hey, don't worry, markets self-correct. One thing that antitrust hardly ever asks is like, well, in how much time? Like in how much time is this gonna take? Is this gonna be quick? Is this gonna take a long time? But in all these cases, like in the Ligon case that I just mentioned, the court just merely says markets will self-correct, but it doesn't surmise into like, will this take a while? So, well, at first that's kind of an empirical question, like does it take a while? To give you sort of with some other people's research, they found that a lot of monopolies and cartels, they last for decades. For instance, General Motors, IBM, Kodak, US Steel, and Harley-Davidson persisted for decades. Bayer had monopoly on some things for 60 years, Monsanto for 30 years, the NCAA, De Beers what's wrong? Empirically, the average cartel, even when antitrust intervenes, lasts about 7 years. And so when some research, 28% lasted at least a decade, 10% lasted 17 years or more. There was a survey that uncovered examples of monopolies and cartels continued for 20 and 30 years. A significant fraction in the survey found that monopolies lasted between fraction of monopolies lasted for decades, over 10 years for between 12 or 37% of them. So in this, notice that like, because you're waiting for markets to self-correct, oftentimes like prices are like high, so there's this harm against consumers that is lasting for decades, and antitrust doesn't intervene because it's like, hey, don't worry, the markets shall self-correct. And it's uncommon for courts to say, well, in how much time will this happen? And there's even a greater problem that goes kind of unmentioned, is that not only are just like prices are high for certain products for a bit, but depending on the product, you can have deprivation, you can have like deserts. For instance, Professor Christopher Leslie wrote a great paper on food deserts. In he found that there's a lot of anti-competitive behaviors that have where after consolidations, big grocery stores leave marginalized communities. And one thing that he found is they use these things called scorched earth covenants that says that whoever buys the property of the old grocery stores when they leave can't open a grocery store here, because their hope is that the people who have now brand alliance at Kroger, Safeway, they're going to take now a bus or a car to like the suburbs to buy food. So they have an investment in not having grocery stores open up there. And oftentimes people don't do that. They go to the dollar stores or they go to gas stations, to buy higher priced and just much worse food. Hospital deserts have created by consolidations where you have not only high prices, but a lot of the socioeconomic harms are driven by time. Things that occur and get worse over time, where people avoid both necessary care and also preventative care. There's even studies that show that people, because of transportational difficulties, when they don't live near a hospital, don't go and they miss cancer treatments. People turn to things like self-medication. Jeremy Kress has done fantastic work on banking deserts. That after consolidations, banks choose to work in more affluent communities and they shutter in marginalized communities, which has caused people to rely on things like title ponds and cash checking joins instead of banks. This has increased, this has harmed people's ability to credit. This has led to higher bankruptcies and unemployment. Even things like property crime has become higher in areas where banks have shuttered. And again, all of these, especially with things like bankruptcy, all of these problems are made worse over time. Childcare deserts is something that antitrust has almost barely recognized. But when private equity buys up childcare facilities, it not only drives up prices and shutters places, but it's caused significant socioeconomic harms that exacerbate over years. For instance, a lot of mothers, especially fathers but particularly mothers, are less likely to take suitable employment or even bow out of the employment market in order to take care of their children. By also taking away adequate childcare facilities, it stunted development and even led to things like malnutrition. So notice, first off, these problems are not evenly distributed. So a lot of the problems that you have with just assuming markets will self-correct are disproportionately take place in marginalized communities. And it actually makes sense when you think about the nature of spending power. Because for markets to self-correct, generally firms are chasing capital. And where there is less capital and more concentration, a lot of times firms chase what's called more higher value consumers. And it's only after competition hits a certain kind of threshold does it become more lucrative to think about the consumers that have so far been left out. So competition needs to be a little greater for things like grocery stores or healthcare competition to increase. The other thing is insular communities can have their own independent needs, which oftentimes are less fulfilled when there is fewer competitors. So due to things like spending power and sort of insular needs, you're finding that the problems like deserts of deprivation that comes up anti-competitive behavior are not, so it's beyond just high prices, but the problems of time are inflicted in marginalized communities at much greater degrees. So one of the biggest questions I want to ask though is should we be surprised that antitrust doesn't talk about time? We think that markets just self-correct and we don't talk about time. Why in the world doesn't antitrust, is it just myopathy? Is there a good reason why we don't say, will this childcare desert self-correct? Will this hospital desert self-correct in a reasonable amount of time, or grocery desert self-correct in a reasonable amount of time? Or why do we just say it's just going to self-correct? So a primary argument of this paper is that antitrust has taken a privileged view of time, a very dominant view of time, and this is in fact sort of this prevails throughout the law generally. So in order to make this statement that it's a privileged view of time, one of the first questions is how? Why would that be the case? And the greater argument that I'll try to make shortly is that because time reflects change. So if you are a believer in the status quo, it helps to slow down change. Why I make this argument is actually a really interesting idea about time just in general, the concept of time. Because it's something, it's really fascinating because we don't really discuss very often what in the world is time as an element or a quality. If you say a time is a measure of time, that's incredibly redundant. So a lot of physicists and philosophers and neuroscientists who talk about what time is, they define it as a measure of change. Because the idea behind that is like, if nothing in the world ever changed, if everything was just permanently frozen and fixed in place, we would have no need to measure time at all, because tomorrow would resemble, yesterday would resemble tomorrow. In fact, there wouldn't even be a difference because we wouldn't have sun up or sun down. It would just, and one of a neuroscientist has defined a clock as simply a measure of change, because that's all that time is just measuring change over time. Because without change, you wouldn't have time in general. And in fact, if you slow down time, you slow down change. That's essentially what a refrigerator does. If you put a tomato in a refrigerator, you slow the aging process. You stop it from rotting or going bad quicker. If you put it on a counter, it ages a little faster. If you put it in a hot car, it ages a lot faster, and it changes much quicker. So in terms of the law actually takes this approach that, like, if we slow down change, if we slow down time, we can preserve the status quo, effectively. So what are the reasons why we want to do this, or why the law wants to do this? A lot of the arguments I see in cases about why we should prefer slower, elongated processes, typically self-help, making people work within existing structures over time. Maybe like, why do we prefer Congress over courts to make decisions? Why do we prefer political debate over just like heavy-handed intervention? One factor that's always mentioned is like, well, more buy-in. Like, society is more likely to buy in on things if we allow debate and allow everyone to come together and not immediately just having a change implemented. Justice Roberts said, when decisions are reached through democratic means, some people will inevitably be disappointed with the results. But those whose views do not prevail at least know that they've had their say, and accordingly, in the tradition of our political culture, reconciled to the result of a fair and honest debate. So the idea is that, like, if you allow everyone to debate, that people are more likely to trust the decisions that come out of it. Another big answer is like unintended consequences. Is that, like, essentially anything we ever do will have unintended consequences. And so if you just have a judge who just kind of lays down the law, more unintended consequences will result. But if you have slower processes like Congress, you can fact find, you can pull back, you can kind of gauge the scope. And so sort of a slower change is much just less likely to break things. Another is just in terms of like, and the people making the change, like judges. Why do we trust judges to just change society for us? Another thing that Chief Justice said is courts are blunt instruments. They do not have the flexibility of legislatures to address concerns of parties not before the court or to anticipate problems. So one thing why courts oftentimes prefer like elongated long-term structures is just like it helps, it creates buy-in. We tend to break things less. It makes a lot of sense to use things like collective action and self-help remedies and self-correcting markets, because that's going to probably hurt things the less and create the greatest amount of problems. To give you some examples of how courts have viewed this in terms of like rights, like let's look at rights litigation. And I thought one interesting case from a long time ago was there was a man in Alaska, Mr. Osborne, who was arrested for rape in like the early 1900s, early 1990s. And when he did so, they couldn't test DNA evidence. And so years later, when DNA evidence was testable by Alaska, he petitioned the court and he wanted Alaska to test the DNA evidence. And the court said no, Alaska said no. And the Supreme Court said that he had no right, to have his DNA tested, even though Alaska could have really easily said whether he was guilty or not. And one of the things that Chief Justice Roberts said is like, look, courts, like each state, they're already coming up with procedures to test DNA evidence. So even if it would be too late for Mr. Osborne and we deny him a remedy, legislatures are figuring this out. And we should just allow the political processes, to play out. Another one, like in terms of civil rights, Martin Luther King, he always complained about, especially in the letter from the Birmingham jail, that he really hated how a lot of people expressed to him how they wanted equality, how they believed in equality, but it just isn't the right time right now. His quote was, equality's stumbling block was anyone who paternalistically believes that he can set the timetable for another man's freedom, who lives by a mythical concept of time, and who constantly advises to wait for a more convenient season. Obergefell case had a lot of the same had a lot of the same concerns. In terms of voting rights, especially Justice Thomas has over and over said self-help remedies should be used instead of often using the Voting Rights Act over and over, and that minority populations should be swing votes and they should form coalitions, but ultimately sort of like self-help remedies should be used. You can also see this in things like the administrative to states decline, where the Supreme Court has said, like, administrative agencies, they can just change their minds all the time. They can enact change too quickly, where at least courts take longer than administrative agencies. The debate about originalism presents a lot of the same issues, where in some cases originalism slows down constitutional change and does not allow judges to drive the change. So we see this like persistent and consistent emphasis for long-term goals. And you see this especially when I'm talking about antitrust law, where in antitrust law there's this huge favoritism against intervention for self-help remedies. But a lot of that brings up the question of, again, like, why? You know, like to give you an example, like in innovation cases, antitrust hardly ever intervenes in innovation cases and product design cases. And a lot of the reasoning it says is like, if antitrust too heavily handed condemned a type of innovation as anti-competitive, well, then we can chill innovation. Like if there's any time you'd ever innovate something, you might be scared you're eliminating competition, and then you would face antitrust liability. And that would have but notice that innovation is a long-term goal. Like your innovation achieves things in the future. And so antitrust oftentimes the courts say, like, well, we're okay with high prices right now because we don't want to upset all these long-term incentives. In Trinco, there was a case where a company avoided a statutory duty to share its networks and created a monopoly. And the Supreme Court again said in that case that, like, yeah, here we think that sometimes monopolies create good incentives. And so we're also not going to condemn this because Justice Scalia said, like, we think that like the market should self-correct in short order. But notice, like, these are all trade-offs. These are all really expressed trade-offs where you're choosing long-term goals over like short-term harms. You're choosing innovation over, because surely a lot of people would rather have cheap pharmaceuticals now versus innovation in the future. So you're choosing kind of one party over the other one. And so I think one of the questions driving my research is, why does not just antitrust, but why do a lot of bodies of law really embrace this long-term viewpoint, have these long horizons? Because oftentimes there's a problem right now that you know that you could remedy, but you choose not to remedy this problem, but you're choosing these longer goals in the future. So the paper argues that this is really sort of like a privileged view of time. And by saying privileged view of time, it's important first to recognize that time as a concept really can vary by culture, by person, how you perceive it, how it affects how you, since time is a measure of change, it kind of reflects what your preferences for change are in society. And in fact, time is not only just a kind of a social construction, it's an actual scientific thing that varies over time. But kind of culturally, a lot of cultures view time in 5-minute intervals, some in 15 intervals. A lot of cultures view time in terms of the task. So if I'm gonna say, hey, I'm gonna paint this fence, people wouldn't ask you, how long will that take? Because that is the amount of time, painting the fence. Beyond that, like a lot of cultures view time as a straight line, and the past is behind you and the future awaits. A lot of cultures view time as circular. Things like reincarnation, where the past can easily reemerge. In terms of scientifically, time moves faster on Mars than in the United States. And one thing that kind of blew my mind learning about is that time on mountains moves faster or moves slower than if you live by the ocean. If there's one person moved to the mountains and lived there for 50 years, and somebody lived by the ocean, and they had watches, and you put them together and they looked at their watch, they would actually be slightly different. So time is not just a cultural difference, it's an actual difference. Einstein was really powerful in this, and he said the past, present, and future are only illusions, even if stubborn ones. Two events that occur at the same moment, if observed from one reference frame, may occur at different moments if viewed for another. So time isn't a fixed structure, and that's kind of an important thing to think about, because it shows that how we view time or how we prefer time in the law greatly changes by culture or who you are, especially by what you think about change. So empirically, how do we view change in time? A lot of the empirical work from more the hard scientists and the sociologists, they found that like how much risk, how much you change that you prefer, oftentimes has to do with how much endowment or deprivation you're facing. For instance, oftentimes the more deprivation that you're facing, the more change you are accepting, how much you're willing to break things to have change. Well, one study of foraging strategies found that people who are facing deprivation are more likely to engage in what appears like riskier behaviors, but really they just need food now, and so they're engaging in riskier behaviors for food now. Whereas if you have more endowment, you're more likely to want to push things into the future and have more risk averse long-term goals. In terms of like investing, people that have faced deprivation seem to be more risk averse, except when the element of time is added into it. But when investments can return immediate gains, people who face deprivation tend to become more risk averse or appear risk averse because they need things now, whereas they discount the future at a heavier goal. If you have a greater endowment, you are much more likely to value the future and not discount the future and in fact sacrifice future current goals. This even affects how we kind of talk about time and change moralistically, where oftentimes there's some studies that show that more affluent people are more likely to talk about self-help, pulling yourself up by the bootstraps and saying you need to work within existing institutions, you need to put in the hard work, this takes time, it takes a lot of effort. But even from a moralistic standpoint, how much change that you think society should undergo right now, or how much self-help and working within existing structures oftentimes depends upon sort of endowment and deprivation. So antitrust, a lot of my argument is, looking into the future, is antitrust should begin to recognize that its current structure, where it favors long-term goals in almost every instance, it doesn't ask about time, is implicitly sort of a dominant or sort of privileged structure where it's favoring long-term goals. Again, in terms of pharmaceuticals, by saying that we should favor innovation over like cheaper prices at this moment, that's essentially like that's a value trade-off about how you feel about change in society. And this very sort of theories about change in time in society is rife throughout the law, whether it's rights litigation that courts shouldn't grant a right now, but it should come from long-term political processes, oftentimes has to do with how invested are you in the status quo? How much do you enjoy the status quo? Or how scared are you of changing the status quo? Or how much if you were more deprived, a lot of times your desire to maintain the status quo will probably be fantastic food. So everyone please help themselves. But how much like you want to preserve the status quo or just are not a fan of changing it. But this also brings up sort of like a tricky question, because all of the Chicago School's theories about error costs and stuff, they're not wrong too, if you think about it. I mean, they are right. Unintended consequences can be bad. A lot of the preserving innovation is a good thing. We want innovation, so we can't just wave our hands at it. So a lot of my argument isn't to say that antitrust should just completely be changed in order to promote like short-term goals, but in some way there needs to be a balance between the two. First, there needs to be just a recognition that time isn't just a static thing that we all experience in the same way and we have the same preferences for change. But I think one of the biggest things is saying, how can we balance these competing goals? Is there a possible way to first recognize how time varies, but also how to balance these goals? So I don't have a great answer. That is one thing that I'm certainly working on. So I'm not gonna spend an incredible amount of time talking about this. But I think that there is ways where first antitrust can ask, instead of like these in terms of communities, who are the people affected? Would this be something that would lead to deprivation? Would this create immediate harmful needs? Would this be something where people who are affected would honestly have a preference for long-term goals, or would they be harmed in the short term? I mentioned earlier the case Ligon, where it was about, the case came out of the Dallas market for artisan lady belts. And And that was a case that was about the resale price maintenance, and that's a case where it makes sense. We can allow the market to self-correct. There's a lot of mass-produced belts. The people who would otherwise buy fancy artisan belts are probably not going to face a lot of deprivation. They can go to Walmart or J. Crew and buy a belt too. So long-term goals, that makes sense. And there is pro-competitive benefits. But there are other types of areas where maybe like grocery store deserts that only affect low-income communities. There, the people who are primarily affected are probably people who would rather have immediate change, who probably don't care so much about some of the supply chain efficiencies that might be created by big mergers. That would be a situation where, in fact, antitrust should probably maybe limit its focus on long-term goals and think about. And there's even a couple cases where antitrust has done this, where there's an anti-competitive case about canned tuna in one case, and the judge was particularly mad because it was essentially only affected lower income communities. The tougher cases are the ones where there's a good balance. The pharmaceutical cases are a good one. The innovation cases, where truly there are situations where like innovation is good, it would probably be problematic to just ignore things like innovation. But it also is problematic to just ignore things like the cost of, pharmaceuticals. And there, I think often it's looking to the environment, like the refrigerator, to see what sort of, in this environment, do we expect to see a quick self-correction? Should this persist for decades? And so a lot of what I'm trying to work on now is trying to create a framework to not just abandon the current framework for a new one and abandon the old one, but try to balance competing demands, I think. And so, but also the last thing I'm going to close on is that I do think it's also important to acknowledge that like a lot of these same concerns are also throughout the law. So it's not just antitrust. So in a way, I'm kind of trying to help play to a bigger dialogue through antitrust law. And so, so with that, that's my article, Antitrust Problem with Time, and please help yourself. Please, I'm sure everyone's hungry. Grab food. But if anybody does have any questions or comments or criticisms, I'm very thick-skinned, so I can absolutely take it, and I look forward to whatever questions people might have or comments.
About just like the changes in like administration, like with the FTC, and like I guess how does that fit into like your understanding of like time and then all the different people that is going to work on antitrust? Similarly, I thought like one of the things that I was thinking about during your talk is that like the political process privileges like the short-term thinking, because like electoral cycles. The people who want to be elected, they want to have something for show in the short term, as opposed to, whereas the law might be able to preserve that like long-term consideration. So like, what is that?
No, it's a really good question. This is actually super fascinating. So we especially saw this under the Reagan administration, when antitrust enforcers really said we're dialing back activities. We're gonna allow markets to play out. So there you really saw how the use of like the political processes really affected and changed things. What's sort of fascinating, I don't know if this is more anecdotal or actually to your question, but at the moment, it's sort of interesting how a lot of the initiatives, like the new merger guidelines that came out from the Biden administration, so far to the Trump administration, it doesn't seem like a whole lot is actually going to change. Like both the FTC and Andrew Ferguson, the FTC, and also under the Slater and the DOJ have signed on to the new merger guidelines. And so at the moment, it doesn't actually seem like the antitrust might change a whole lot at the moment, whether that turns out to be true or not. I mean, we're only a couple months in, but that's a really good point that I need to write down there, because I think, yes.
Wait, how come it wouldn't change if there's so many of the big tech people whispering like Trump's ear and like, I guess.
No, I hear you. So I think that's I guess it's interesting to see whether it's changed yet, but it seems like it does seem like that is a good point, because under so far there hasn't been a lot tangibly changed. Whether we'll see much change in terms of policy, I think that we'll see that comes into fruition. But I think that you make a good point though about how that affects time, because if people do want to see, theoretically, I guess the question is, how responsive do you think are political processes? You know, like how much do people vote, and does that affect antitrust or other policies? Because I think you could say that, well, every 4 years, people have a chance to change antitrust policy if they want to. But whether that's actually a big consideration in voting, or how responsive are political processes to voters, I think is more questions. But I think that is an important question, because you certainly can show that that is almost like an artificial or a time frame that you're imposed in there. Every 4 years things could change. But it seems like at the moment, some administrations things change. I think perhaps like what made the advent of the Lena Khan administration, like there you probably saw bigger changes and also the Reagan administration. So yeah, so the administration is so the political concerns of administrations is something that I should certainly incorporate. Yes.
Firstly, I love this project. Thank you for sharing it with us. I've never heard someone discuss antitrust law using all of this. I know that you finished this project, but it sounds like you're digging into something much bigger. And so I'm just gonna add something to the table that I read about, but I never made the time connection the way you have, just in case it's helpful to you for future projects.
I'm still working on this.
Oh, wonderful.
Yeah.
So I was reading about the whole domination framework, and I can send you the material that I was reading. It was a series that was kind of looking at company power versus lawmaking power at all.
Okay.
And I feel like it's possible to relate it to time because of one line in David Harvey that compares the way capitalists work, saying that basically a transnational capitalist company has infinite time and infinite space because of the scale at which it operates, and because the company has its sort of capital-driven goals and the people keep changing, as opposed to territorial government, which based on your conversation, it just, like his other part is territorial government has electoral cycles and is contained.
Oh.
And so there's the way that both operate is just completely different, and government is constrained by time. Whereas companies have infinite time, they can wait.
Yeah, that's a fantastic. I'm really like right now my mind is going crazy. I'm just trying not to get distracted. I'm thinking about so many things. Because that's the whole idea of the corporation is like it's a fictitious individual with theoretically it's an immortal fictitious person that and so that's interesting. So those things can actually embody goals or time frames that are different than the people that either on government or even the short-term managers of a corporation. Oh, that's a fascinating way to view sort of like the timing. I'll definitely have to read the specific works that you're talking about, but I think that's a really cool way of also thinking or like adding into this. It's just the nature of almost the corporation in general and how they view time versus like us mere mortals.
Hi, Greg, I really love the project, and I think it's really thought-provoking, these long-term goals over short-term harms. And I, as much as I love it, I disagree with it.
Oh, okay.
And the reason is because you're applying it to antitrust cases in healthcare, right? And I'm thinking here, usually healthcare has been explored as, especially in the US, driven by free market spirits and corporates, right? Being the main deliverers of providers of care. But there is a scholarship growing and growing in the last year saying that healthcare is mostly financialized. And if we zoom into these financialized actors, they are not really concerning long-term goals. It's absolutely the opposite. We're talking about private equity firms. And so they are more concerned with short-term goals because you just want to get into the asset, make some revenues and get out. And they speculate based on their future value. So they really don't have all that time to sit down and wait until capitalism, makes them profitable is the opposite. So, and actually, I'm exploring not from the antitrust angle, so I would love to, make some intersections there with your work. But I'm thinking in how the use of public funding in the pharmaceutical industry has a lot to do with this time perspective. When we think in innovation, the actors there are not thinking innovation as a collaborative, long-term process, but they're thinking it more as a, they are creating a short-term goal with a long-term harm, which is the products of the innovation in the pharmaceutical space are no longer accessible.
Mhm.
So just to challenge, I don't know.
Oh, no, it's a great point. I really want to
for
gauge this.
pharmaceuticals,
Yeah.
and probably we can apply that statement in other areas of healthcare. But when I think in innovation in the pharmaceutical space, it's absolutely the opposite as a result of the financialization of healthcare.
No, I think this is also what I think is really fascinating, and what is a good point, but also to talk about this is that, so this actually fits to me, we can talk about this more, but I think this fits actually perfectly in there. That because I think companies a lot of times do favor short-term goals. And so companies, oftentimes want short-term, it's antitrust that is thinking about the long-term goals of innovation. But it's the companies that are very much thinking about short-term goals. And one thing is that one reason why monopolies persist and markets don't self-correct is because ideally they would, but frequently, companies invest a lot of money to maintain their monopolies, right now. Let's go to the pharmaceutical or just innovation industries. One way that people protect their patents in anti-competitive ways is, let's say you have a patent on a drug that really shouldn't be patented. If anybody challenged your patent, they would easily be found not to be a patent. So one thing that companies do is they litigate the hell out of it. They sue other people for patent infringement, even if they know that there's very little chance your patent is good. Because if you're a more powerful corporation and you have a greater war chest, the spending all that money to litigate, because I think last year the average patent dispute is $3.5 million, something like that. And if you just sue in innovation cases other people, it's considered anti-competitive to engage in sham litigation, where the only point of the litigation is just to force your counterpart to spend money that they don't have, because that then causes them to just acknowledge your patent that doesn't exist. But this is absolutely a desire for short-term goals. And so this is what the actual mismatch. Because companies do sham litigation, I want to say all the time, but somewhat all the time. And their goal is these short-term monopoly profits. But antitrust is the one that is worried about these long-term innovative activities. So what you're saying is that antitrust is caring about the long-term in ways that the companies who are engaging in the behaviors aren't.
Right.
And so that's actually a mismatch, but you're completely right. And if anything, that just shows to me the difficulty of antitrust worrying about these long-term goals when the maintenance of monopoly power is a very short-term, immediate goal that companies have. And a lot of the reason why, and generally things like sham litigation is supposed to be, anti-competitive, but so many of the assumptions against, things that we consider things to be pro-competitive are so strong that the antitrust is so scared to condemn innovation that it essentially says we are going to, if it's a coin flip, we're assuming this is pro-competitive. Or we'll flip this coin 9 times and we think that it has, only if it lands on heads twice will we actually, engage in these behaviors. So in fact, it very much is, so this is actually a part of time that's actually really important, and that I'll certainly incorporate in there is how companies think about time is much different than antitrust enforcers in a problematic way.
That's fascinating, and that also will lead to probably think about consumer protection law.
Yeah.
Again, in a mismatch with antitrust law, they are more focused in the short-term goals rather than.
Yeah, no, and especially I'll definitely reach out to you later because if you have any really direct points on in the healthcare to talk about their short-term views, because I think that would be extremely helpful to add in there to show how enforcers in courts and antitrust courts are on completely different wavelengths than the companies that necessarily they're supposed to be scrutinizing. Yeah.
I'm sorry if you already addressed this, but I know you mentioned, antitrust is just one area of the law that deals with this time problem. So I wonder, sort of in addressing like why we should begin to deal with the problem in antitrust, like what you see as particularly important about antitrust and figuring out the concept of time, or if there's something about antitrust law that tends to be the case in other areas of law, so figuring out this time problem in antitrust will then help us sort of with downstream effects. Like I guess just making the normative case, for why we should start with the time problem within antitrust as opposed to elsewhere.
So this is kind of it's like one of those things, I'm at the point in the article where it's like, it's completely, I've kind of gotten the bare bones, but there's still a lot of chance to write it. And so I've only had people essentially read kind of introduction. And one of my friends who read it, his first question is like, is this an antitrust paper or is this a time paper? And I think that's exactly what you're sort of getting at. And the answer is, I don't know. And so I think the only reason why it's so far an antitrust paper more than the other ones is just because it's easier to write like a narrowed paper. But I mean, it's a writing problem, not like a bigger problem. So in the idea of thinking like, so how much do I get into things like voting rights litigation? Like, does that make the paper unwieldy? Does that suddenly make it not succinct? Is that something that you just got to sit down and figure out how to do it? But is that something where you just have a little implication section at the end where you talk in 5 pages how this could potentially be expanded? Or is this like part 5, and I'm struggling with, and that's a great question that I'm struggling with. Like, is it something that, one reason why I'm doing antitrust is because that's kind of an area that I know a lot of. But 2, I think it's just few areas as perfectly encapsulate this time issue by saying, let's just wait for self-correcting markets. And the courts expressly say, these current costs, we should worry about the future. But yeah, I am really interested. I'm not sure, and I think I would in some way like to meaningfully make sort of the bigger normative case in just sort of like the law writ large.
Well, I think even just saying something like antitrust, encapsulates this problem perfectly. That is part of the reason why I've chosen to focus on it. Like, I think for me, thinking about, the idea that courts tend to be, 25 years behind, the real world in many different cases, like just sort of nodding to why, you've chosen to start with antitrust is probably all I would want to see.
Yeah, no, that makes sense. And I'm always, and it's one of those things where if you saw the drafts as I'm going in, like that's the one area where like through the drafts you can see like it suddenly is like half antitrust, half like and the rest, and then it's like, all right, well let's pare it down and just make it just a nod to it, and then like bigger, and but that's so I appreciate the encouragement to make it a bigger focus and say this is just like but one element of it.
Really quickly, because this is kind of related, I was just gonna say the other thing that's kind of unique about antitrust when it comes to time is how you can turn back the clock in antitrust as well. And even mergers that have been approved by the FTC can, decades later be challenged without really a statute of limitations. And I feel like that the Facebook, Instagram, WhatsApp case that's happening right now, where suddenly the courts are trying to like look back, imagine themselves at the time of the merger, what they knew, what they could have said, to like imagine this counterfactual world of like, what if this merger hadn't gone through? Would Instagram have been a Facebook competitor or not? And so there's like
the old
a different
divestitures.
way.
Where you go, that's like breaking up things that you've already
But just like years and years later is unscrambling the eggs, all that kind of thing. But I feel like that's another unique feature of how antitrust law looks at time.
No, if I haven't read any of that yet, but if I don't, that would be a big error and omission. So I really appreciate that.
This was super interesting, thank you. I get a bit confused with the answer you gave to the first question, so this is more a clarifying question. As I understand it, and I'm not an antitrust person at all, the Chicago school has been lately replaced with a different framework. So there was this neoliberal framework, and now we have the new rendition framework. So I was wondering, and that's actually the one that Lina Khan tried to bring to the FTC, right? So is this criticism against, or where do you see this approach to time and change? Is it in the first framework or in the second framework or in both of them you can see?
Yeah, I mean, so it's sort of tricky because one is like, so far, like, this is an area where a lot of times you see enforcers up working, not necessarily hand in hand with courts. so under the court, so the courts haven't really changed many of their precedents that like to adopt sort of like a neo-Brandeisian framework. They're still sort of working under the same precedents. So I think to a lot of areas, you are seeing changes where now antitrust is less about prices and now things like privacy and Google and Facebook, those are sort of big changes. But I think the law itself hasn't overwhelmingly changed. They've just been kind of fit in, whether it's been more uncomfortable fit, and other times it's fit nicely into sort of like into the old framework. Like we're gonna call privacy equality, adjustment, which is part of antitrust. So far, I don't think you've seen like these radical changes as much as it seems like it. And you kind of see that with the degree how the new administration really hasn't expressly changed that much so far. So I think a lot of the new neo-Brandeisian things have been kind of snuck into antitrust, but it hasn't but the model hasn't changed, Yeah.
Super interesting, thank you. Sorry, I had to step out in the middle.
Oh yeah, no problem.
I think it was right before I stepped out when you were talking about Legion and how we don't really care if it takes a long time in belts, but we do care if it's daycare centers or grocery stores. And I'm wondering whether you feel like this framework of valuing time, of thinking about the time cost, especially when you think about like a per se standard and the error costs that come with that versus a rule of reason standard, whether you think that the optimal solution is to differentiate by subject matter, or whether we can come up with one solution that works across subject matters and maybe it is focused more on the markets that affect low income people more, but it also applies to all markets. I think it's interesting. It's kind of a subset of issues within your bigger issue.
No, 100%. And I played around with this kind of in the past, and I've kind of tried previously making the case, and I still think this is true. So like I said, so antitrust, like that whole Legion case was about artisan belts. Like it's not like a really earth-changing, a market where if this market was harmed, that our quality of life would so suffer as Americans. But I've talked in the past, I still believe this several times, about the idea of necessities. Things that tend to have inelastic demand, where you're going to purchase the same amount, sort of like no matter what, or you likely would. And those sort of like necessary, critical at things like healthcare and food. I've tried to make the case like those should get a different sort of standard under antitrust. So actually, I didn't mention the talk, but it is sort of in the paper where I do talk about generally when deserts arise, I mean those are necessities, things that we kind of need. And so one way, sort of cleaner way of just saying how antitrust should view time would be like, is this a necessity with inelastic demand? And to the degree that it would, that would seem to be a more objective, cleaner way of saying, of having a gauge of saying like, is this something that like maybe we should act faster and have less deference to like self-correcting markets?
Is it necessary to also say then that for those markets, we're okay with if you kind of buy the Chicagoan school, that we're potentially okay with lower innovation in those markets?
Yeah, and I mean, I guess so. And that's what I'm saying.
I don't disagree.
No, I think it's really difficult, but there's other things I wanted to say, so I think a lot of times, I do believe a lot of what the Chicago school says, about value and innovation, and maybe you could incentivize it. I don't think they're wrong. So as I was thinking, that's to me, I was writing the paper, I was just like, gosh, I don't know how to resolve this, because I do think that is tough, and I especially think about things that even more are when it comes to pharmaceuticals and stuff, is gosh, I don't want people to stop innovating that type of stuff. And it does seem sort of short-sighted and populistic to just be we have to have lower prices right now. But gosh, it feels like there needs to be some sort of balance or trade-off where we at least sort of recognize or make carve-outs. But no, I agree that that it's the classic of is this lion longer than this boulder is heavy, how do you balance these two very important things? And then of course you're just, maybe the answer is just to let judges be judges and try to figure it out and not and allow, and you'll probably have some where some judges will say one thing and others, but versus just saying where you're just restrained to like favoring the longer term goals.
So if I can follow up on
Yeah,
that, my
please.
concern about that answer, when we just let judges be judges, that sounds a lot to me like the rule of reason, which then starts to become, well, the transaction costs at the time and the ability of litigant to drag out the time, which is what we started with here, is enormous. And so I think the reason to go towards per se rules is to eliminate judge discretion, in some extent to eliminate the time cost and the transaction cost.
You know, that's something I don't talk about at all. I don't talk about it all, is that per se eliminates time costs.
Yeah.
I don't mention that at all. That's a really good point.
Well, that seems like that's kind of what I thought you were getting at with Legion. It's like, well, we got rid of the per se, and yeah, it maybe makes sense for belts, but what about these other areas and the time costs?
Yeah, I mean, implicitly that suggestion is there, but I don't like come out and say that, you know? And I think that's a great point, and I think that has to be, you know, I mean, that's a really good point, that has to be in there. So I mean, I guess you could make an argument about maybe like using like per se or more like quick looks about like certain areas where time is perhaps a bigger issue. So I think that makes you know, I really think that's a super important point that has to be.
One other, I'm sorry to dominate here, one other doctrinal point is that may help is like, right, we've gotten so far away from direct evidence of market power, and so everyone's always trying to prove up markets and market shares. And in lots of cases, it's like, well, we have a pretty damn good sense that this person is charging a super competitive price. But we don't allow them to rest on that, and we make them prove markets. That all those transaction costs slow things down and make things more expensive. And so also like crediting maybe like leaner evidence of direct market power.
No, I mean, that's a great point. No, thank you. Yeah, I mean, because I didn't really talk much about like the actual litigation of it, but I think like litigation is like, how can you ignore, when we talk about time and costs, I mean, how can you not talk about like litigation? You know, I only think I do talk about sham litigation, but like there, I'm assuming that like, that just takes a minute, you know?
Right.
No, fantastic. No, thank you.
Thank you so much for this talk.
Thank you so much.